is the final order of the maintenance lordship. I am the wife lordship. Reason is filed by the that section 125 has been dismissed only on one ground, holding that only on cross-examination it has been stated by the wife that she does not want to live with the husband lordship.
Yes.
And other reason has not been assigned by passing the order lordship. She has said that they have given the cruelty lordship and there is offence is pending for 498A. That has been not considered lordship. That order may be seen lordship.
Which paragraph?
Page number 16 lordship, para 17.
Yes.
पेज 9 है जो जजमेंट है। पूर्वतः साक्ष्य प्रमाणित हो चुकी पति के साथ में रखने के प्रस्ताव को पर्याप्त कारणों के बिना रहने से इंकार की है और बिना उचित कारण के पति से पृथक रह रही, ऐसी स्थिति में आवेदक अनावेदक से भरण पोषण प्राप्त करने के अधिकारी नहीं। इसका एविडेंस देखेंगे सर। PW1 लॉर्डशिप, व्हाई शी हैज स्टेटेड दैट शी डज नॉट वांट टू लिव। PW1 पैरा 12
मेरा रिकॉर्ड है क्या लिखा?
PW1 पैरा 12 है। नेक्स्ट पेज से आएगा सर क्वेश्चन आंसर जो आया हुआ है। क्वेश्चन है, आपका पति आज भी आपको अपने साथ अच्छे से रखना चाहता है, आप जाना चाहोगी? उत्तर है, मैं पति के साथ जाना नहीं चाहती, पति के घर में मुझे जान का खतरा है, मेरे साथ मारपीट करते हैं। देयर इज ऑलरेडी FIR लॉर्डशिप। ये फिर नेक्स्ट है, आपको पति आपको लिखित में आश्वासन के साथ कि मारपीट नहीं करेगा, अच्छे से रखे, तो आप जाना चाहोगी? उत्तर है, मैं पति के साथ 2 बार रह चुकी हूँ, अब मुझे पति पर विश्वास नहीं, इसलिए मैं नहीं जाऊंगी। She has specifically stated that there is a sufficient ground why she does not want to live lordship. And section 125 subsection 4 also say lordship. That may be seen lordship. If wife says there is a sufficient ground why she does not want to live and there is a FIR also case is pending against them, then only on the statement that she does not want to live, order has been passed against me. That 125 subsection 4 may be seen lordship. No wife shall be entitled to receive or interim maintenance and expenses of proceeding as the case may from her husband under this section if she is living in adultery or if without any sufficient reason. She has assigned reason that why she does not want to live. She refuses to live with her husband lordship or living separately by mutual consent. Then 5 say lordship, on proof that any wife in whose favor an order has been made under this section is living in adultery or that without sufficient reason she refuses to live with her husband or that they are living separately by mutual consent, the magistrate shall cancel. The wife has assigned reason that why she does not. And the husband has not filed any application with regard to the restitution of conjugal rights. They have not moved any petition. Only in the cross-examination, the question has been asked that whether she wants to live. She has denied and specifically raised that there is a cruelty and case is pending against. And in the cross-examination of the husband, earlier he has said that there is no proceeding of 498 pending. Then in the cross-examination, he said that there is a proceeding pending, but it is a false case. Therefore, the order passed by the learned family court may kindly be satisfied, lordship, and the maintenance amount of ₹15,000 be granted to the wife.
Yes, बताइए.
The learned family court rightly rejected the application by the doctor respondent wife because इन्होंने मैडम पैरा 14 में जो दिया है स्पेसिफिक ये है, मैं थोड़ा सा 14 से बता रहा हूँ. पैरा 14 इन दी जजमेंट महफूज अंसारी ने उसकी साक्ष्य में यह अधिकथित किया है कि निकाह के बाद 15 दिन उसके यहाँ रुकी थी. समाज के लोगों ने बातचीत की, मुश्किल से पत्नी उसके यहाँ आई. 4 दिन रुकने के बाद पुनः मायके चली गई. यह स्वयं कई बार और समाज के अन्य लोगों के माध्यम से पत्नी को लाने का प्रयत्न किया. पत्नी वापस नहीं आ रही है. वह पत्नी के मायके गया तो पत्नी की मां ने उससे कहा कि उसकी बेटी से घर का काम करवाते हो, उसे आराम नहीं मिलता है. तो उसने कहा कि उसके घर में मात्र 3 सदस्य हैं, ज्यादा काम नहीं है. उसने पत्नी के साथ रखने का पूरा प्रयत्न किया. पत्नी के विरुद्ध कोई शिकायत दर्ज नहीं कराई गई आज तक. पत्नी बिना किसी कारण के उससे अलग रह रही है. वह पत्नी को किराए के मकान में अलग से रखने के लिए तैयार है. पत्नी मजबूर करे तो वह पत्नी के साथ उसके मायके में भी रहने के लिए तैयार है. इसके अलावा मैडम पैरा 15 ऑफ द जजमेंट लास्ट 4-5 लाइंस जो इन्होंने शिकायत की है उसकी बाकायदा फाइंडिंग्स जो दी हुई है फैमिली कोर्ट ने, वो उसके बारे में बताना चाहूंगा. प्रदर्शनी 4-5-6 घटना दिनांक 12/4/21 का उल्लेख नहीं है. NCR रिपोर्ट 15/4/21 में दहेज मांग के बारे में उल्लेख नहीं है. शिकायत प्रदर्शनी 5 किस दिनांक को की गई, किस दिनांक को थाना हनुमानतल पर प्राप्त की गई, इस संबंध में सील व हस्ताक्षर प्राप्त संबंधी नहीं है. इसमें घटना दिनांक 12/4/21 का भी उल्लेख नहीं है कि प्रथम सूचना रिपोर्ट प्रदर्शनी 6 दिनांक 9/5/21 की जो घटना से कई महीनों बाद विलंब से दर्ज कराया जाना दर्शित होता है, जिसमें घटना दिनांक 12/4/21 भी उल्लेख नहीं है. तब पति साक्ष्य की संपुष्टि शिकायत रिपोर्ट प्रदर्शनी 4-5-6 से नहीं हो रही है. इस प्रकार पत्नी की साक्ष्य एवं दस्तावेज में घटना दिनांक के संबंध में ही विसंगति है. उस दशा में पत्नी की यह साक्ष्य की दिनांक 21/4/21 को पति ने दहेज की मांग कर मारपीट कर घर से निकाल दिया, यह मान्य किए जाने योग्य नहीं है। ये इनकी अभी जो ये बताना चाहते हैं सब हमारे पास सफिशिएंट रीजन है, हमने शिकायत की है उसके बारे में बता दूंगा। पैरा 16 महफूज अंसारी उसने प्रति परीक्षण की कंडिका 7 में इस बात को स्वीकार किया कि निकाह के 3 माह बाद समाज की बैठक बुलाई गई थी, तब पत्नी उसके घर पर वापस आई थी। इस तथ्य से पति की इस साक्ष्य को ही बल मिलता है कि निकाह के बाद कुछ समय तक पत्नी ससुराल में रहने के पश्चात मायके चली गई थी। तब समाज में बैठक बुलाई गई जिसमें बातचीत होने पर पत्नी वापस नहीं आई और पुनः मायके वापस जाकर रह रही है। इसके बाद इसी आगे मैं और बताऊंगा। पति के घर में पति और उसके माता पिता रहते हैं, ऐसी स्थिति में पत्नी को घर का काम करना पड़ रहा होगा और उसे आराम नहीं मिलता होगा। इससे बचने के लिए पत्नी पति से पृथक मायके में रह रही है, जबकि पति ने पत्नी को खुश करने के लिए हर तरह से साथ में रखने का प्रयत्न किया। पत्नी उसके साथ ससुराल में रह सकती है। पत्नी चाहे तो वह किराए का मकान लेकर उसके साथ रह सकता है। पत्नी चाहे तो वह उसके मायके में जाकर भी रहने को प्रकट किया है। नूरी अंसारी ने उसके प्रति परीक्षण की कंडिका 12 व 13 में पूछे जाने पर कि पति ने यह प्रकट किया है कि वह पत्नी को हर तरह से अच्छे से रखना चाहता है और लिखित आश्वासन देता है कि वह पत्नी को अच्छे से रखेगा, कभी मारपीट नहीं करेगा, तो पत्नी ने प्रकट की कि वह साथ में नहीं रहना चाहती है। तो हम इनके ये हमारे यहाँ आके रह लें, हम इनके यहाँ रह लें, ये कहीं किराए के मकान में बोले तो वहां रह लें,
जैसा घर भी आके रहने
सब स्थिति में तैयार ले जाने के लिए तैयार।
ज्यादा क्या बोलेगा
Lordship, he has stated in the application reply, Lordship, but he has not filed any judicial proceeding with regard to the
saying is stating he was examined, he states
and Lordship, there is a case is pending, criminal case is
even
pending.
he has given an option that even he ready.
Still I am ready, Lordship, still I am ready, but only before the court in the examination chief he said, but there is no effort has been done by the husband, Lordship. And there are 2 proceedings are pending, domestic violence and the 498 of. Earlier he has denied that no cases is pending.
This is a revision arising out of order dated 20th October 23 by which Family Court Jabalpur has dismissed an application moved by the petitioner under section 125 CRPC 1973. The facts reveal that the marriage of the applicant as well as respondent was solemnized as per Muslim rites on 21/3/2020. Later on account of certain matrimonial disputes, a report against the respondents was lodged under section 498 of IPC. The respondent and the applicant also filed an application for grant of maintenance under section 125 CRPC and claimed maintenance to the tune of rupees 15,000. The application of the filed by has been dismissed by the trial court. While observing that, since the applicant has refused to cohabit with the husband without any sufficient reason, thus she is not entitled for grant of maintenance. Counsel for the applicant contended in the present case there is failure on the part of the court to appreciate the sufficient the explanation pertaining to the fact that there were sufficient reason which compelled the present applicant to live separately. The counsel, while taking this court to paragraph 12 of the testimony of PW1, that is, the applicant has stated that it was specifically stated by the applicant that as she was manhandled at matrimonial house, therefore she was not willing to reside with the respondent. She also stated that as her past experience was bitter, hence, she has no trust in the respondent. Therefore, since there was a reasonable explanation by the applicant wife, thus the court has heard in passing the interim order by which the maintenance has been declined to the applicant. The counsel has placed reliance on the decision of the apex court in the case of Muhammad Abdul Samad versus State of Telangana, and it is contended by the counsel if the wife is subjected to cruelty, she has sufficient reason to not to cohabit with the husband. The contra counsel for the respondent submit that the trial court, after due sifting and analysis of the evidence, has rightly came to a conclusion that the applicant wife is not entitled for maintenance. The court has considered this testimony of the applicant as well as respondent elaborately in paragraph 16, and after upon due appreciation thereof, the court has arrived at a conclusion that without there being any sufficient cause reason, the applicant has declined to cohabit with the respondent slash husband, as the applicant is not entitled for the maintenance. The respondent counsel for the respondent has supported the judgment of the trial court while placing reliance on this to the Rajasthan and Mumbai. No other point is felt or argued by the parties having considered the submission advance on behalf of the parties. If the application 5 under section 125 CRPC by the applicant wife is perused carefully, it would reveal that there are no such averment in the entire application, that that the presence of the applicant wife was not being tolerated by her in-laws. Full stop. It is further evident from the perusal of the content, from the perusal of the application under section 125 CR. It was nowhere mentioned that there was any threat to the applicant in the event if she makes any attempt to live along with the other applicant. This aspect has been duly appreciated by the family court in paragraph 16 of the judgment. The family court, while placing in the application the contents of the application while under section 125 CRPC in juxtaposition with the testimony of PW1/applicant, has come to a conclusion that without there being any justified reason, the applicant has refused to cohabit with the applicant. The court has also appreciated the testimony of the respondents, and wherein he clearly stated that he was willing to reside with the applicant even at a rented premises, and if the applicant was willing, in that case, in her house as well. This testimony of the respondent makes it abundantly clear that there was no refusal on the part of the respondent to live along with the present applicant. On the contrary, the family court has rightly arrived at a conclusion that there was willful denial at the behest of the applicant in not residing with the respondent. Hence, this court is of the opinion that the family court has not committed any error while passing the impugned judgment. The reliance on the decision of the apex court is misplaced in as much as the case is virtually distinguishable. Accordingly, revision stands dismissed.